So good morning, everyone. You're very welcome to today's webinar. My name is Tara Brady. I am a Principal Management Consultant within Ark Workplace Risk, and I'm here with my colleague David Hill, Senior Director in Ark, where we will be going through the Fire Safety Residential Evacuation Plans England Regulations 2025, all in regards to person-centred fire risk assessments and personal emergency evacuation statements. So before we begin, I would like to talk a bit about Ark Workplace Risk and who we are and what we do. So within Ark, when you partner with us, we very much empower you to confidently manage your risk, your safety, compliance with a true partnership built on expertise and innovation. Within Ark, we have over 30 years industry leadership, and we very much serve as that extension of your team. We deliver tailored solutions to protect your people, your properties, your operations for that complete peace of mind. So our approach within Ark, we combine industry's top consultants with our intuitive CUDA platform, and this simplifies your compliance management. So it saves you time to focus on other critical tasks or elements of your day-to-day. But beyond that, we guide you through complex, contentious, and critical situations, and we give you that confidence and provide you with tools that give you that overall well-informed decision-making in any scenario. So for today's agenda, what we will be going through is an overall introduction to the regulations and where they have stemmed from, and talking on the Grenfell Tower Inquiry, the government's response. We'll go through the draft regulations in great detail and the overall process and how it's to be introduced. The draft arrangements and process in terms of person-centred fire risk assessments and personal emergency evacuation statements. We'll also go through building emergency evacuation plans and how, as responsible persons, this needs to be managed and actioned. We will be allowing time for questions at the end of today's seminar, and they'll be monitored throughout. So we will begin by looking at a poll to understand our audience. So if you own or manage a property, residential block, does the block have a formal evacuation plan in place for vulnerable persons? So yes, no, or you're not sure. So we'll give you 30 seconds. Okay, so we can see from the poll we've had 61% have said yes, so very, very high. And then we have 14% not sure and 24% no. So our yes is growing, so that's really, really positive to see. Okay, so we'll end the poll, and I will now hand you over to Senior Director David Hills, and we'll commence today's session.
Good morning, everybody. I hope you are well. My name's David Hills, Senior Director at Ark. I've been with Ark for over 24 years, actually. I was a building control officer, but I've worked very specifically recently as working with clients in respect to the Building Safety Act. What I want to do today is to take you through an introduction. And I thought the best way to do that is to actually look through the history of how we've got to where we are in respect of the new regulations that are being proposed. So I'm not going to go through and take you through what actually happened on the night that Grenfell occurred. But following Grenfell, we actually had a Grenfell Tower Inquiry, who was chaired by the Right Honourable Sir Martin Moore-Bick. Now, in October 2019, he actually made recommendations that suggested that every high-rise residential building should be required by law to prepare personal emergency evacuation plans, or PEEPs, as they are like to be called, for all residents whose ability to evacuate the building without assistance may be compromised. And that included people, as they suggested, with reduced mobility or impaired cognition, and to include current information about them and their associated PEEPs in the premises information. box. Well, the government accepted immediately all of those recommendations, but it wasn't until June 2021 when the actual government published its proposals and sought views from industry regarding PEEPs, especially within high-rise residential buildings. I think it's fair to say that the response that the government received regarding this wasn't particularly well received, and so therefore the government in May 2022 published further proposals and sought views on a system that they called Emergency Evacuation Information Sharing Plus, known as EEIS Plus. Now, that effectively was about providing information to fire and rescue authorities rather than going down the PEEPs route. PEEPs were effectively rejected. And the government suggested the reason for that was that they were very effective in workplaces, but they didn't feel that they were appropriate in residential premises. The problem we had over the period directly after that is we had lots of contradictory statements from various ministers who actually suggested that either PEEPs were perfectly acceptable or that EEIS Plus was perfectly acceptable. And it culminated effectively just before the election last year with the minister actually suggesting that he felt going forward that PEEPs would be a valid approach. Well, moving on from that, in September last year, the Grenfell Tower Inquiry Phase 2 report was published, and it made again a very, very clear statement that the further evidence that they had received in the course of the Phase 2 had confirmed their view that the responsible person for a general needs residential building should collect sufficient information about vulnerable persons or occupants to enable appropriate measures to be taken to assist their escape in the event of a fire. They also suggested that the guidance that was contained within the local government guide on fire safety in purpose-built blocks of flats should be reconsidered. And in addition, they made and suggested that much of the evidence relating to the individual deaths emphasized the importance of being able to provide fire and rescue services with reliable information about vulnerable persons and those who needed rescue. Okay, so we've gone from the first inquiry to the second inquiry. We've had two lots of government consultations. And then in December last year, the new government released the results of the EEIS Plus consultation. And it was very clear that EEIS Plus wasn't the way forward. And ultimately, the response suggested that they would be moving towards what's called a residential personal emergency egress plan. And they also then made a very clear distinction between residential PEEPs and workplace PEEPs. I'll go into a little bit more detail later on regarding that. Now, in January this year, the government released and published draft regulations to Parliament called the Fire Safety Residential Evacuation Plans England Regulations of 2025. And they were placed before Parliament for internal discussion. There has been no vote on the recommendations and the actual regulations themselves at the moment. We are waiting to find out how the government intend to deal with that. But yesterday, we had the government's response to the actual Grenfell Tower Inquiry Part 2. And the government confirmed that they accepted all 58 of the Grenfell Tower report recommendations and intended to push ahead with the implementation of the Fire Safety Residential Evacuation Plan England regulations of 2025. They also suggested as well, just as some background information here, that they were looking to extend the definition of a higher risk building and also we'll be looking to introduce revised and updated guidance on vulnerable persons. So the LGA guide, as I said, is being reviewed, and they are expecting to be able to produce a new version of that within 25/26. And in addition to that, they're looking to actually provide further guidance on general fire safety as well. So the history has had quite a lengthy time to get to where we are now for something which actually is a statutory instrument. Many statutory instruments can actually just take up to 28 to 48 days in which to go through Parliament. This has taken since the 2018 introduction of the actual Grenfell Tower Inquiry report. So we've had a long time to actually understand exactly where the government is going. And to be honest with you, it's been a very, very haphazard approach to developing what is actually a relatively simple process that the government have now introduced within these new draft regulations. Okay, so we now know the history. Let's have a look at the actual draft regulations themselves. Now, the draft regulations are focused on two particular areas. They're focused on what's called specified residential buildings, and they are focused on relevant residents. So I want to start off looking at the process by focusing and honing in on those definitions. So the definition of a specified residential building has been defined within the draft as a building which is located in England, containing two or more sets of domestic premises, and which, as with the Building Safety Act, are at least 18 metres in height above ground level, or has at least 7 stories. Now you'll notice I've put the "or" in there. And the reason why I put the "or" in there is because in addition to that, these draft regulations are going to apply to, again, specified residential buildings that are above 11 metres in height and have a simultaneous evacuation strategy. So we can already see that the definition of higher risk building is leaching in to the new regulations that are being proposed by the government. Now, just a quick note, because it's been very interesting that the government at the time, when the Building Safety Act came out, introduced guidance relating to how you measure a building and the number of stories. And there's been criticism about the guidance issued by the government because it doesn't tend to actually follow what's actually in the Act. There are some problems with both. What we have now, though, within these draft regulations, we've got some interesting additional elements to the definition of a specified residential building. The building effectively says that a story which is completely below ground is to be ignored. And what they mean by completely below ground is that the finished ceiling in that story is below ground level, immediately adjacent to part of the building. So any part of that building that has a ceiling below ground level, then that particular story is to be ignored. In addition, they've put in here guidance relating to what's called mezzanine floors, and suggested that if a mezzanine story has a floor area of at least 50% of the internal floor area of the largest story, then again, that is another floor. If it is below 50%, then again, it is to be ignored. Just one thing though, and I think it's important that we just mention it, but it's important that we actually understand that the regulations are not going to apply to military premises, including any barracks. And interestingly, and I've got no understanding why, but it's how the regulations have been formulated, is that they're not going to apply to any domestic premises within the House of Commons or the House of Lords. So that's our definition of what a specified residential building is. So these regulations will only apply to those particular types of building. Okay. Let's move on then to looking at the definition of what we call relevant residents. So the regulations will only apply to those persons who meet this definition, and they are a permanent resident of a specified residential building whose ability to evacuate the building without assistance in the event of a fire is compromised as a result of cognitive or physical impairment or condition. So we've got that definition. Now, interestingly, there is no additional means of interpreting that particular statement contained within the regulations. I will be going on later on to have a look at some suggested types of cognitive and physical impairment and conditions that could be included that have been considered by the British Standards Institute. But at this particular moment, that's what we've got. Now, the term permanent resident has been defined again within the regulations as a person who is named on the tenancy agreement for a domestic premises in question, or a person who resides permanently in a household occupying the domestic premises in question. I would imagine that the first question we're going to get is, well, hold on a moment, what about build to rent? What about if we've got short-term lets? Well, unfortunately, if there is a tenancy agreement, which normally is in place within those types of buildings, then we do therefore have to consider that that they would be a relevant resident if they were compromised as a result of a cognitive or physical impairment or condition. So we've got the definition of the specified buildings. We know which buildings these regulations apply to, and we now have a definition of what a relevant resident is. The difficulty we have, as I said, is determining what we mean by cognitive or physical impairment or condition. And for that, I've turned to the British Standards Institute to see if they could, in fact, help us. We currently have at the moment a draft British standard called BS 9792, which is due for release sometime this year, which deals with fire risk assessments in housing, and it's a code of practice. And within that particular code of practice, it sets out a list of those persons who, in the British Standards view, have specific evacuation requirements and characteristics which could impact their ability to evacuate from a residential building. And so they include, for example, the partially deaf and the sighted, partially blind or partially sighted, the deaf and the hard of hearing, persons with physical impairment, persons with breathing or heart conditions, persons with sensory or neurological concerns, neurodegenerative conditions such as MS and ME, cognitive impairments, as well as being morbidly obese or bariatric, having chronic fatigue conditions, persons who may be suffering from communication impairments, the ambulant disabled, the temporary injured, or persons who are pregnant, as well as the elderly with what's called an acquired condition. And the acquired conditions are all those actually detailed above on the top layer there, as well as others who may have drug or alcohol dependencies. Now, I want to be very clear. This is not a definitive list. This is the suggested list by the British Standards Institute. It is not enshrined within the regulations. We have to, though, go back to and look at those areas that will actually have a cognitive or physical impairment or condition. And if any of your residents have that, then they could be classed as a relevant resident. And in showing you this actually just explains what the current view is in respect of where that definition could lead us down. Okay, so we now know what the potential relevant resident conditions are. what do the actual regulations actually require of responsible persons? Now, the regulations are very clear. They are aimed at responsible persons. Now, responsible persons in this instance are going to be owners of buildings, freeholders of buildings, as well as managing agents as well. So the regulations apply, as I said, to the responsible person. Right, let's have a look at this approach that the regulations have now introduced. They've set up a 5-stage approach to how we should be dealing with vulnerable persons. The first thing is that the responsible person has got to identify relevant persons. Once they've done that, they've got to offer and undertake what's called a person-centered fire risk assessment. Now, out of that risk assessment, there may be actions that are required, in which case you are duty bound to agree how you will mitigate those particular risks. Once you've done that, will be a requirement to agree what's called a Personal Emergency Evacuation Statement. So we are not moving down the PEEPS route. This is a Personal Emergency Evacuation Statement. And once we have done that, we then have to notify fire and rescue services. So it's a simple 5-stage approach that is actually going to be enshrined within the legal process. So what I want to do now is just hone in on those individual elements. So first part then, we've got to identify relevant residents. So this is a proactive approach that responsible persons, so that's owners and managing agents, as I said, they have got to use, what the words are, they must use reasonable endeavours to identify residents who are relevant residents. There are going to be many ways in which to do that. Writing to residents using resident portals, apps, all those types of things. But the most important thing is that you've got to use reasonable endeavours. The next stage is about undertaking a person-centered fire risk assessment. Now, again, under the new regulations, responsible persons must offer to undertake a person-centered fire risk assessment. I'm going to call them PCFRAs from now on, for each person who appears to be a relevant resident, and ensure that the PCFRA is carried out for each person who requests one. So it's really important that we understand this is a must do. If you identify a relevant resident, or if a resident asks for a person-centered fire risk assessment, then you are duty bound to either offer it or undertake it. Now, the regulations make it very clear what the person-centered or PCFRA has to cover. And it's got to include, firstly, an assessment of the fire safety risks inside the resident's domestic premises. So the resident has got to cooperate and coordinate. The resident has got to allow access to the domestic premises in the first place. If they refuse that, then it's very difficult in order to undertake a PCFRA. In addition to the domestic areas, there is a requirement to assess the fire risks within the common parts of the building. And then in addition to that, the PCFRA has got to consider the resident's ability to actually evacuate from the building in the event of a fire. So that's the process by which the regulations require it. I'm going to step back very quickly to the draft code, BS 9792, because that has also set out a proposed approach to how you develop a PCFRA, and it's a 9-step approach to actually developing the whole process. And they're based around simple steps like determining the characteristics of that particular resident. So actually trying to understand what are the issues that that particular person has, whether it's a hearing problem, a sight problem, a mobility problem, cognition problem, or any other of those ones I mentioned earlier. Step 2 is about then determining the potential causes and the likelihood of fire within the 2 areas that we have spoken about. the domestic areas and the common areas as well. We then got to identify the circumstances that could lead to rapid fire spread. So, for example, someone may be using oxygen within their particular domestic premises. Well, we've therefore got to identify that increased oxygen can lead to rapid fire spread. We then, on step 4, we've got to identify the existing fire safety measures that are already in place. And then we've got to consider what is the likely response to a fire alarm or signs of fire that that particular resident would actually understand. So if they are, for example, hard of hearing or deaf, they would not be able to hear a traditional fire alarm system. So we need to consider the likely response requirements for the individual residents themselves. We've then got to consider whether the resident themselves can make their own way to a place of safety. Now, it doesn't say that that place of safety has to be outside the building. We could be using refuges within the building as long as they have the right degree of protection. And then we're getting them to a relative place of safety. We've then got to consider all of steps 1 to 6, and then effectively determine the level of risk to the resident from fire. Following which, we therefore then need to prepare an action plan to how we can remove or reduce those risks. And the final stage, step 9 in the whole process, is that we've got to determine a period of review. The regulations have led us down a particular approach in respect of review, and they are suggesting that we should be looking at least every 12 months. One thing I would suggest, though, based on what's been happening in the industry in the last few months, if you are going to engage a third party to support you, or if you are going to undertake the PCFRAs yourself as a managing agent, please make sure that you have the required level of insurance to do it, the right degree of insurance, whether it is an aggregated version or whatever way, and that you have the right competence to deliver that PCFRA. Okay, we've gone through stage 1. We've identified the relevant residents. We've now undertaken our person-centered fire risk assessment. Stage 3 is all about mitigating those risks. So following the completion of the PCFRA, the responsible person, again, must discuss and agree. Now, I think that's going to be an interesting part, because how can you must agree? There may be certain situations where you do not have that agreement, but you must discuss and agree with the relevant resident the reasonable and proportionate measures that the responsible person and the resident may take. So the regulations are not stating that everything has to come down to the responsible person. Not everything is going to be focused on the responsible person. There will be proportional and reasonable measures that the resident themselves will have to take. What the law, though, will require is that you must agree on how the costs for these measures are to be allocated. So you're both responsible person, managing agent, and the resident have got to decide whether the resident will bear the cost of mitigation, or whether it's service charge, or whether there is a mixture. And that will have to be discussed, and it will have to be very specific to the particular freeholder, leaseholder regulations and arrangements in place. Interestingly, though, the law is saying that you then must implement those agreed measures. So we can't just undertake an assessment and then forget about any mitigating areas. We have got to, by law, implement those measures. And this is very much how the Building Safety Act is now starting to push us down. And this is just really an extension of those particular requirements. We do an assessment, we therefore have to do something with the recommendations and the actions. Okay, we've identified the relevant persons. We've undertaken a PCFRA. We've undertaken and mitigated all of the risks. What do we do next? Well, the next thing we have to do is to agree a personal emergency evacuation statement. Now, again, the responsible person must use all reasonable endeavours to agree with the resident the contents of that statement. I think the difficulty we've got at the moment is that there is no guidance as to what a personal emergency evacuation statement is going to have to include. At this particular moment, there is nothing out there that supports it. We've got guidance in respect of PCFRAs, we've got guidance in respect of what may constitute a relevant resident, but we don't have anything in respect of personal emergency egress statements. But what the law does say is that a personal emergency egress statement should set out the approach to the resident's evacuation in the event of a fire, and the agreed approach must be in writing. Now, I mentioned earlier that during the government's approach to developing this, they were looking at the differences between workplace personal emergency egress plans and residential emergency egress plans. So I think it's worthwhile just having a look at how the government in their current guidance have suggested where the differences actually sit. They suggest that workplace PEEPs are actually designed to elicit action prior to the attendance of any fire and rescue service personnel. And clearly they're going to be utilised in both retail and commercial premises. So workplace PEEPs are aimed at actions prior to the attendance of fire and rescue services. Residential PEES, or personal emergency evacuation statements, are designed to outline the action taken during a fire situation, and that would include the actions of fire and rescue service personnel. So that's the main difference between a PEEP and a PEES. We've got to start thinking about two different elements. Workplace PEEPs are fine for retail and commercial premises. Residential PEEPs will look at how we can use our own methodologies as well as the support of fire and rescue personnel. So the next stage we move on to then is all about notification of fire of the PEES to a fire and rescue service. Now, again, the regulation has been very clear in that the responsible person should not notify fire and rescue service personnel without the consent of the resident themselves. So the resident has got to agree that they are happy for you to share that information. I find it difficult to understand why a resident wouldn't, but there is a possibility that a resident may not agree. What the responsible person has got to do is to provide the local fire and rescue service personnel with following information: the resident's flat number and the resident's floor number. And in addition to that, you've got to provide basic information regarding the degree and the type of assistance that resident may actually require, as you've deemed and you have agreed during the development of your PCFRA, your mitigation of risks, and the writing of the personal emergency evacuation statement. And the final part you've got to produce is whether the actual resident has a statement themselves. So again, you can provide information relating to the resident's flat number without consent, the resident's floor number without consent, the type and nature of assistance, and whether the actual resident has a PEES. But you cannot, therefore, though, provide a copy of that emergency evacuation statement without the permission of the relevant resident. Now, the local fire authority, once they've received information like this, have got to inform you, the responsible person, how it wishes to be provided with information, and they can either choose it to be electronically or by inclusion as a paper copy within the secure information box. And if you do not have a secure information box, then the law requires you to provide one where this is actually necessary. So the process is quite lengthy. The process, I would suggest, is quite costly. But it's actually now how the government have decided that they can deal with vulnerable persons within residential blocks. A lot of people were very unhappy with PEEPs, but I think what we've now got is an extension of that whole process to actually now include that person-centered fire risk assessment, which is going to be quite a lengthy document, because we've got to consider both the risks inside the flats and the domestic premises, the risks outside of the flats, and how that particular resident is able to deal with a fire scenario, as well as agree those particular statements. Now, you're going to have situations where the actual relevant resident themselves, because of any cognitive or physical impairment or condition, is unable to participate within this process. And the regulations allow for that and suggest that the responsible person may act on instructions from a person who is authorized to act on the resident's behalf by firstly requesting the PCFRA, by discussing the mitigating measures, by agreeing the PEES, and then consenting to providing information to the local fire and rescue service. So where we have an issue where we are unable to work with, because of the cognitive or physical impairment or condition with a relevant resident, then we can work with other persons who are authorized to act on their behalf. Okay, so that's the process of actually dealing with residential evacuation plans under the regulations. So I just really want to run, if we can, another poll. So I'm going to ask my team if we can run the next poll for me, please. So I really want to find out what do you consider would be the main barrier to implementing or approving evacuation plans for vulnerable persons? Do you think it's a lack of awareness from residents, it's limited resources or funding, poor communication from residents, or a lack of training, or whether you have a transient resident cohort? So it would be good if we could have your views on that over the next 30 seconds. Okay, so it's very interesting at the moment that we've probably got 2/3 of those who have responded so far suggest that there is a lack of awareness from residents and obviously limited resources. So that's an interesting element. So that's going to be something that I think many organizations, many responsible persons are going to struggle with in the application of the new regulations. Okay, if we can stop that then, and I want to move on now to the last couple of slides, and then hopefully if there are any questions, we'll see if we can answer them. So the next section I want to deal with then is the final regulation within the actual draft, and that is the requirement to produce what's called a building emergency evacuation plan. I could hear lots of people shouting at me at the moment saying, well, we already produce these. And you're right, you already produce foreseeable risk procedures and certain other procedures that you will handle and supply to residents But the regulations have made it very clear that the responsible person must prepare an evacuation plan for a specified residential building in the event of a fire. And they're calling it a building emergency evacuation plan. Now, in addition to the actual plan, which, by the way, they have not provided us with any guidance on what that should include and what the difference is between that and those required under, for example, the Fire Safety England regulations, or those required under the Regulatory Reform Fire Safety Order, or even those required under the Management of Health and Safety regulations. So we at the moment just understand that we have got to provide a building emergency evacuation plan. What we have also got to do is we've got to provide a copy of that building emergency evacuation plan to the local authority, local fire and rescue authority, sorry, and that where the building has a secure information box, then we have got to provide a copy of that within the box. I say that guidance hasn't provided us with information as to what must be included, but what the regulations say is we've got to include a copy of any instructions to residents relating to the evacuation of the building that you would normally require under the Fire Safety England regulations. We've also got to include information as to whether there are or not any relevant residents, and if so, whether those residents have any PEES. And in addition, we've got to provide information relating to other arrangements for evacuating the building. We do not have information relating to that. The last thing I just really wanted to talk about before I answer any questions is that the law has made it very clear, the draft regulations have made it very clear, that the responsible person must review that evacuation plan no later than 12 months after the plan was first prepared and before the end of every period of 12 months thereafter. So effectively, annually, that building emergency evacuation plan must be reviewed. And they have then made it very clear that if, as a result of that review, that plan requires amendment or updating, then the responsible person must, as soon as reasonably practicable, provide a copy of that amended or updated plan to the local fire and rescue service, and again, put a copy within the secure information box where that actually applies. So we have a requirement, therefore, that we should be reviewing these plans every 12 months, a legal requirement. Okay, so just as I just want to finish off then and just talk about the actual regulations. We believe, we understand, following yesterday's announcement, that in 2025 we will see the application of these regulations. We do not know if there's going to be an implementation period. Currently, within the draft, there is no implementation period proposed. So I would not rely upon it if I was you. I think it's really also, we should note that whilst we've gone through those draft regulations, that those regulations haven't gone through Parliament yet. They are therefore subject to change and amendment. I think it's really important that we recognise that they only apply to England. And by the way, they can be applied to Wales, but the Welsh Synnodd have got to consider them and apply them to Wales through their particular processes. And I understand from yesterday's announcement that they are considering how they are looking at that based upon their own building safety and fire safety regimes that they are implementing. And the last thing I just really wanted to mention before I deal with any conclusions is that I think we ought to all be prepared for a raft of additional regulations over the coming year or so, specifically as a direct response to the Grenfell Tower Inquiry. The government have made it very clear that they are looking to deal with the urgent issues within 25, early 2026. So I think over the next year, we are going to see significant additional regulation, extension of definitions, as well as the requirements, as I've set out here, to provide person-centered fire risk assessments, and personal emergency evacuation statements. So just a few takeaways then. The new regulations come as a direct recommendation from the Grenfell Tower Inquiry. They were in the first inquiry set of recommendations, and they have been reinforced within the second inquiry in respect of delivering PEEPs for adoption in residential buildings. That the new regulation applies to all high-risk buildings, plus any residential block that is over 11 meters in height, but has a simultaneous evacuation strategy. That they apply to relevant residents, and those relevant residents will require assistance in the event of a fire, and they only apply to vulnerable persons, and that the definition goes much further than just mobility issues if we believe that the BSI definition would be used. And I've a understanding from talking to ministers and to the regulator, for example, that the BS 9792 proposed standard is something that they are very much supportive of. The definition, as I said, goes much further, but the process is actually based around 5 steps. You have to identify the relevant persons, undertake a PCFRA, mitigate any risks, and agree ultimately and develop a personal emergency evacuation statement, and inform the local fire and rescue service. In addition to that, the regulations require you to develop, publish, and keep up to date a new building emergency evacuation plan. As I said, it's very likely that these will pass through the parliamentary process in 2025. So I would strongly suggest that we start working towards meeting those particular requirements, understanding at least your resident cohort. But again, just so we are very clear, the regulations are subject to change and amendment, but it's very unlikely, and that they only apply to England, although, as I said, Wales can adopt them as part of their approach to building safety. So hopefully that's given you a flavour of what the new processes are required. And I'm going to ask Tara if she can moderate any questions that we have.
Great, thank you, David. So we've had a few questions come through. If anyone else would like to submit their questions while David is answering, please do so in the Q&A, and we will try our best to get to them. Okay, so the first question, David, is where we look at our person-centered fire risk assessments. How often should we be expected to review or refresh these assessments?
Okay, I think it does depend upon the characteristics of the individual. I would suggest that if someone is pregnant, for example, then there will not be a need for that to be reviewed once that individual has given birth. Same in respect of someone who has an injury. But if someone has a long-term cognitive condition or a physical impairment, then at this particular moment, the guidance that's being suggested is that they should be reviewed annually. Cognitive conditions and physical impairments can change, both improve and obviously worsen. And so that's the reason for the current recommendation of an annual process.
Okay, great. The next question that we've had come through is, how do we define who the responsible person is when it comes to completing the person-centered fire risk assessments?
The definition of responsible person comes under the Regulatory Reform Fire Safety Order, both in England and Wales, and it's very clear what and who that is. And that can, in fact, be more than one person. And when I use the word person, I'm talking about the fact that that could be and is most likely going to be a body corporate.
Okay.
So a responsible person is a person who's effectively in control of a premises or part of that premises. So it's very clear that an owner or a freeholder is going to have control over that particular building. But in addition, managing agents are considered to be responsible persons. There's various amounts of case law that that make it very clear that managing agents are responsible persons as well. So I think we're going to need to see and agree between the managing agent and the owners of a particular building who takes responsibility for dealing with this. I think we all know where ultimately it's going to end up.
Yeah. Yeah. Okay. Next question, David. Previous definitions of a resident is anyone living in a building over the age of 16. However, there doesn't seem to have been any mention of a minimum age here. Does this mean it now applies to under 16s as well?
Yes.
Yes.
Yes. It's as
Okay.
simple as that. Yeah. This is the definition of 16-year-old is included within the Building Safety Act. That is very specifically in respect of resident engagement. I know it's used elsewhere as well, but that's specifically where that 16-year-old de minimis has been provided. In this instance, it doesn't matter the age of the resident, it's whether that resident is a permanent resident. So either it's unlikely that someone under the age of 16 will be able to sign any agreement, lease agreement, but that comes under the second element that they permanently reside within that particular building. So yes, it doesn't really matter about age. We're talking about any resident who has a cognitive or physical impairment or condition.
Okay. Okay. The next question we've received, can we log any of these assessments on the CUDA platform?
Yes.
Yes, great.
Yes.
The next question we have is where we have issues with residents denying access, or if the resident has moved out or there's a sublet scenario, have you any views on any best practice techniques to help overcome these barriers?
I think it's very clear that the regulations and the government themselves understand that the relationship sometimes between a resident and the responsible person may not always be where we would like it to be. And that's the reason why they've suggested that responsible persons must use reasonable endeavors. One of the areas that we've certainly been working with a number of our clients on this is that writing to residents on a regular basis is a good start, but we also have to recognize that some residents may, and we may already know that some residents may not be able to read. They may not be able to, they may be blind. They may also have cognitive or neurodegenerative conditions that prevent them from reading and understanding that. So it's really important that we don't just focus on one methodology. I think we need to start thinking about multiple approaches. Writing to residents is a good start, but I think we need to think about how we use the resident engagement process that's within the Building Safety Act, especially for buildings that are considered to be high risk buildings, and how we can use that and adapt that to support this process. The problem we have, though, is that the resident engagement process doesn't deal with buildings that are 11 meters to 18. And so we need to start thinking a little bit out the box about how we go about determining and making all those reasonable efforts. At the end of the day, you can lead a horse to water, you can't make them drink. If a resident doesn't want to support the process, doesn't want to get involved in the process, is unwilling to engage, then there's very little that the responsible person can do. But I think very importantly, it's about making those reasonable endeavors and recording what you have done. And the fact that you recognize that just writing to somebody is not going to be acceptable, that you've come up with an alternate way. It may be that you have posters at reception or at the entrances. It may be that you have details on any app. We've got to be able to show that we've made those reasonable endeavors. And so therefore, I would strongly urge you to think not just about writing, but other methods about how you can capture that information.
Great. Okay. Now we've had this question a number of times in the chat. When it comes to our residential buildings where we have a confirmed stay put policy, is this still required?
It's still required in stay put where the building is in excess of 18 meters or 7 stories, and it's considered therefore to be a high risk building. But just remember that definition may change, especially with the government introducing and accepting the recommendation of the Grenfell Tower Inquiry to extend the definition to cover any building which includes vulnerable persons. So at the moment, if you have a stay put policy and your building is above 18 meters or 7 stories, then these regulations will still apply. They will not apply to a stay put policy building that is between 11 and 18 meters.
Okay. We've had this also another question, David. When it comes to us implementing this, is it worthwhile now that we have an awareness of these potential legislative changes? Would it be beneficial to start drafting internal policies and procedures so once it's enacted, we are ready to action in a quick
I think
succession?
that is an absolutely superb approach, and it's one that certainly we are recommending to our clients. I think if we just wait for this to be enacted, we don't know if there's going to be an implementation period. We could find, for example, similar to some of the secondary legislation that was produced following the Building Safety Act, that we are sometimes given 2 weeks to deal with something, and in some instances we were giving no time at all, that they were immediate. So I think it would be a very, very good idea for responsible persons to start putting procedures in, even starting to talk to residents as well about this, if they haven't already done so through the resident engagement process.
Yes, okay. And the last question, I think, just considering the time we've left, when it comes to looking at competence for people completing these assessments, do you have any advice as to how we would proceed with looking at sourcing people to do this for us?
I think ultimately we're going to be all forced down a particular route. One of the recommendations within the Grenfell Tower Inquiry is that fire risk assessors should be registered, and that they should have registration through a UCAS-based system. The code of practice does say that they believe that PCFRAs could be undertaken by people who maybe don't have the degree of competence to produce a full fire risk assessment, but then it contradicts itself and suggests that actually there will be a need to understand how fire risks within the common areas are dealt with in order to provide and produce a satisfactory PCFRA. I think ultimately PCFRAs are going to have to be undertaken by registered fire risk assessors. That's certainly not in the law at the moment, but if we extrapolate what's recommended within the Grenfell Tower Inquiry and pass it through to here, I think it's going to be very clear that we're going to need to ensure that someone who has an understanding of the skills, the knowledge, the experience, and the behaviours as well that are appropriate to this process. I think we're going to find that this process is going to be very difficult to actually deal with. There needs to be a significant degree of empathy, but there's also needs to be a significant degree of proportionality and pragmatism, because We are not going to be able to, in certain buildings, we're just not going to be able to implement and mitigate all of the risks for certain types of cognitive or physical impairment or condition. So I think we're going to need to think about the whole process. But I personally think if we forward and horizons scan, that we're going to see a situation where we need to be thinking about registered fire risk assessors in the long run. We'll need to undertake this. I might be wrong, though.
Okay, thank you, David. I'm conscious of time, so I think we'll leave it there for the questions. But thank you everyone for joining today's session. Please do let us know in the Q&A if you enjoyed our session today and what you liked about it. And if you are happy for us to utilize this in our marketing, please also leave your name and job title. That'd be much appreciated. So thank you very much, and thank you, David.
Thanks a lot. Have a good day, everyone.
Thank you.